Quillian. I'm at Taylor English Dumel with my colleagues in our litigation department. This is Litigation Fundamentals with Henry Quillian. And we held this on a regular basis at Taylor English to discuss amongst ourselves and to provide to you information regarding interesting legal topics that are likely to directly impact the practical aspect of your litigation, or in this case, arbitration practices. As we repeatedly tell everybody, we are not here to provide you with legal advice as your counselors. You need to rely on your own research and your own lawyer. And if you're an independent person without a lawyer acting pro se, we recommend that you get a lawyer. But one way or another, we are not providing legal advice to you as your counselor. The topic today relates to the Federal Arbitration Act and a specific portion within that associated with obtaining evidence from non-party witnesses. And I found this to be a very sticky issue and a very problematic one. The Federal Arbitration Act has been widely used in recent years. It's stuck into all sorts of agreements that mandate the use of the Federal Arbitration Act. So there are so many different types of transactions that may involve the Federal Arbitration Act, and it's important to know how you're going to have to go about getting your evidence in order to present a case or to defend a case under the Federal Arbitration Act. Starting from the top a bit, the Federal Arbitration Act is at 9 U.S.C. Section 1 at SEC, and that lays out the basis of the Arbitration Act, which was passed in 1925. And specifically, we're going to be focusing on Section 7 of that Act, witnesses before the arbitrators, fees, and compelling attendance. The problem comes up that the Federal Arbitration Act does involve arbitration between parties that involve interstate commerce, and virtually anything these days could be argued to involve interstate commerce. And also a whole lot of contracts specifically say that the Federal Arbitration Act will apply to the resolution of disputes arising out of or related to the contract. And of course, we have another litigation fundamentals on the drafting of arbitration agreements, and they can have a extremely broad breadth, or it can be more narrow based on the terms of the contract. But one way or another, you're going to need to have witnesses, and a lot of times those witnesses are not employed by your party, or not. If it's an individual who has signed the contract, there may not be any employees. Everybody might be a non-party witness. And if you are representing a corporation or some other sort of legal entity in the dispute, very often with the transitive nature of employment these days and the interstate performance by companies in a lot of different states, a lot of times people have left the company, moved to a different state, somehow become disassociated with a party, and it becomes a huge issue to get them to come provide testimony at an arbitration hearing. One of the things that will be clear by the end of this is it's very important to know in advance, perhaps before you enter into a contract, where the locale of the arbitration is going to be and where the arbitrators are going to be. And when you're selecting arbitrators, if they're not all in one place, where they are, because depending on what federal circuit you end up in, your rights to discovery and to bringing witnesses to an arbitral proceeding can be dramatically different. And that is something that was surprising to me, is that depending on where you are in the United States, even though you're under the Federal Arbitration Act, you might have substantially different rights. So focusing on the issue of bringing testimony from non-parties, this would be somebody who is not under contract to arbitrate, to an arbitral proceeding, and also getting documentary evidence, and when you can get documentary evidence. Let's look at Section 7 of the 9 USC Section 7, Section 7 of the Federal Arbitration Act. I'll read the first rather long sentence. The arbitrators selected either as prescribed in this title or otherwise, or a majority of them may summon, doesn't use subpoena, may summon in writing any person to attend before them or any of them as a witness, and in a proper case to bring with him or them any book, record, document, or paper which may be deemed material as evidence in the case. That sounds fairly straightforward until you compare it to the rights and remedies that you would have under the the Federal Rules of Civil Procedure in civil litigation. And there's a case that came out just pre-COVID in the 11th Circuit Court of Appeals, which for us highlights a lot of the ifs, ands, and buts about how do you actually get a witness to come to an arbitration, especially if you want documents from that witness, and how do you get the documents in any way, shape, or form in advance of the actual hearing before the arbitrators, because you would normally expect to be able to do that as part of discovery in an arbitration or a proceeding, like if you're in federal court, but you might not be able to do it at all. There may only be one solution, which is taking the witness live before the arbitrators at the hearing with all their documents in hand, however voluminous. And in complex commercial litigation, that can be difficult. So the case that brought this to my attention is one entitled Managed Care Advisory Group, LLC versus Cigna Healthcare, Inc., 939 Fed 3rd 1145, 11th Circuit 2019, decided in September 2019. And that case holds very straightforwardly that in the 11th Circuit, arbitrators cannot cause to bring about pre-hearing discovery from any non-party witness. And that would include document retention or testimony. So we'll walk through how it got to that conclusion, but that means that if you're relying on documents that a non-party has and their testimony, you have to figure out a way to get that person to the hearing, wherever it may be. In this instance, it would be a hearing somewhere in the 11th Circuit, and have them bring all their documents to the hearing and somehow or another use those documents in connection with the testimony while you're actually presenting your case, perhaps with no opportunity in advance to learn what's in those documents. And that was a surprising thing to me, especially in construction litigation or patent litigation, where you might have an arbitration provision and you may have huge numbers of documents that impact the outcome of the case, and to help make a determination regarding what the outcome should be and what the cross-examination of the witness should be, or otherwise the presentation of your case. So let's see how they came to that. Well, it's pretty straightforward. First of all, the 11th Circuit found that that the district court had what's called ancillary jurisdiction as its subject matter jurisdiction for the district court, pursuant to a preceding, already closed, essentially, class action suit where the court had maintained jurisdiction for purposes of enforcing a settlement agreement between the class plaintiffs and the defendants. So that resolved the subject matter jurisdiction issue, but we'll get to that later, which in turn is also an extremely sticky issue. So the district court found that it should compel testimony from a non-party witness, but to a virtual deposition instead of a virtual appearance before the arbitrators instead of in person before the arbitrators, and the parties contested that. The 11th Circuit found it had an appellate rights because the issuance of the decision by the district court it found was a final decision that was appealable because there was nothing else. There were two orders issued, and those two things were all that were for the district court, so they found that it was an appealable set of decisions. And they just went directly to the words of the Federal Arbitration Act, which I said was issued in 1925. And they read that first sentence, and that first sentence says, may summon in writing any person to attend before them or any of them as a witness in a proper case, and in a proper case to bring with them any book, record, document, etc. So what the court did is it looked to 1925 dictionaries to determine what to attend meant. And let's see if I can find the quotation. It's a very long case. It found that to attend meant to be in the presence of, I think is what they found there. And which meant in the presence of the arbitrators. And to bring with them meant that to bring it to where the person is. And so they determined that under the Federal Arbitration Act, the only option was for evidence from non-parties to be brought before the actual live arbitrators at the place of the hearing. And therefore, the proposed summonses that were issued would not be enforceable because that's not what the parties had asked for. That's at page number it's in head note 22, I guess is the best way of putting it, within the managed care case. So what they held was that the federal government, the Congress had decided that the Federal Arbitration Act had issued this ruling, this statute, and the purposes of the statute was to make resolution of cases more straightforward, that it did not provide for pre-hearing discovery, that it only provided one mechanism for bringing witnesses before the arbitral proceeding, and that the words of the Section 7 said that such evidence had to be presented in person before the arbitrators. Now, there's, however, a split in the circuits on this issue. The 11th Circuit decided to follow the 2nd, 3rd, 4th, and 9th Circuits in determining that the statutory language was unambiguous and that that's the only way that evidence could be brought before the arbitration proceeding. Now, I circulated to y'all in advance a case from the 8th Circuit, International Seaway Trading Corp versus Target Corporation, which is 2021 U.S. District Lexus 31755, 2021 Westlaw 672990, February 2021. And in that case, the proposed proponent, who was a non-party former officer of Seaway, sought to quash a summons where he was asked to come testify. And the court held that under Federal Arbitration Act and Eighth Circuit precedent, an arbitrator has the power to subpoena a third-party witness during pre-hearing discovery. And the court basically rejected a whole series of arguments that were made by Mr. Satz, the proposed opponent, that were based on the 11th Circuit, 4th Circuit, and other circuit cases, 9th Circuit cases. In addition, Mr. Satz attempted to apply the territorial limitations of Rule 45, and we'll get to that in a minute, relating to where somebody can be sought to comply with a summons or a subpoena under Rule 45, and the 8th Circuit District Court in Minnesota basically determined those aren't relevant either, and we'll go into why that is. Now, there's some there's some interesting contradictions that take place within these cases. On the one hand, people say, well, arbitration is to make things more efficient, and therefore there should be no pre-hearing discovery, and everybody should just bring all their evidence to the hearing and then sort it out there. And the argument against that is, well, what if there's tons of documentation that has to be gone through, and you're bringing these people with piles and piles of documentation to a hearing, nobody's seen it in advance, nobody knows what it says, nobody knows what's to ask of the witnesses, and basically people are bringing in piles of documents. And so some people will say, well, it's totally, the Eighth Circuit will say, well, it's totally inefficient to have all the documents brought to the hearing, and that ruins the purpose of arbitration. And other appellate courts say that makes arbitration totally efficient because everybody will bring it to the one hearing. There won't be running around the country getting discovery. There won't be any of this, overturn every stone type discovery. So the courts can't even decide what's more efficient. I thought it was sort of funny in this case that it said there's just a flat statement that says taking depositions is extremely burdensome, whereas document production is not burdensome. Well, my current experience is that document discovery is extremely burdensome, and getting a deposition, if all you want to do is ask somebody questions, isn't nearly as burdensome as getting their documents, especially in the world of e-discovery and emails and all that. So basically, it would seem the courts just sort of make up an excuse based on their own personal experience regarding what's more burdensome and what's not. So we have the issue of, let's assume that you do actually get a summons issued. To where can you send the summons, and where does the person have to come to in order to provide the testimony? Well, and there are cases debating that. The Rule 7 says, if any person or persons so summoned to testify shall refuse or neglect to obey said summons, upon petition to the United States District Court for the district in which such arbitrators or a majority of them are sitting, may compel the attendance of such person or persons before said arbitrator or arbitrators, and punish said persons or persons for contempt in the same manner provided by law for securing the attendance of witnesses, or their punishment for neglect or refusal to attend the courts of the United States. Well, we all know that Rule 45 of the Federal Rules of Civil Procedure is the designated subpoena portion of the rules, and the courts have uniformly held that Rule 45 is what is referred to as the law for securing attendance of witnesses and for their punishment for neglect and not attending. Well, that's all fine and good, except that what what they're talking about here, of course, is you're in the middle of your arbitration proceeding, the hearing, the actual hearing itself. You summons the person, they don't show up. Well, now you've got to decide, how do you go about getting that person to come and give the testimony or provide the documents? Well, first of all, it's pointed out that in 2013, keep this in mind, there was a revision to the Federal Rules of Civil Procedure, Rule 45B2, which allows nationwide service of subpoenas in federal district court actions. Notice it says that the parties may serve a subpoena anywhere within the United States. But what is not addressed is where the person must actually testify. Well, the courts have held that under the Federal Arbitration Act, that unless a monumental showing can be made by a party seeking to quash a summons by an arbitrator, essentially the non-party witness has to show up wherever the arbitration is being held. All right, and of course, we've also looked at where do you enforce the subpoena. Well, it's expressly stated in Section 7 of the Federal Arbitration Act. It has to be in the United States District Court for where the arbitrators or a majority of the arbitrators are sitting. Well, what if the arbitrators are in 3 different districts? I mean, 3 different circuits or in different districts from one another. It's unanswered. I'm not aware of any case that says, how do you break that tie regarding which district you have to bring the motion to compel in if you're the party seeking to have the evidence. I've got an arbitration right now. We've got 2 arbitrators in North Carolina who are in the 4th Circuit, one who's in Atlanta in the 11th Circuit. So, for instance, in that one, we're assuming a 4th Circuit rules will apply, and that the district court that's in North Carolina that's closest to the locale of the hearing, as opposed to where the arbitrators are actually sitting, will be the one that applies. So, first of all, so we've already determined where you bring this action, and then the question is, what action do you bring and what's the jurisdiction to bring it within the federal district court? Well, you would presume that it's based on the words of the Federal Arbitration Act, which say you need to bring it in the United States District Court, which I read a minute ago. However, the managed care case, which I was discussing, expressly holds that the Federal Arbitration Act does not give rise to federal question jurisdiction. So if it does not give rise to federal question jurisdiction, and you do not have ancillary jurisdiction, such as there was in the managed care case, can you even get into federal court to compel a witness to appear at an arbitration proceeding or hearing before arbitrators under the Federal Arbitration Act? Well, perhaps not. In Amgen versus Kidney Center of Delaware, 95 Fed 3rd 562, 1996, the court held that if you cannot plead or don't plead diversity jurisdiction to establish that the underlying arbitration was between fully diverse parties, then there is no jurisdiction in the federal district court to compel a witness to appear before a federal arbitration proceeding, which to me terribly undercuts the Federal Arbitration Act, because now you have no ability to enforce a summons by an arbitrator issued in a Federal Arbitration Act proceeding. at least under the express words of the Federal Arbitration Act. Maybe you could try to bring the action in some sort of underlying state court action based on the State Arbitration Act. But I'll point out that the Georgia Arbitration Act does have much broader, within its own words, much broader discovery rights and third-party discovery rights than the Federal Arbitration Act does. So, to achieve this, you have to actually summons the person. You have to serve it like you would serve a subpoena, a summons. Then you have to see whether they show up at the actual hearing with all their documents. If they don't show up, you've got to somehow go to the district court in the district where the arbitrators or a majority of them are sitting, get an order, get the people to come, if you can establish diversity jurisdiction or some other sort of jurisdiction in the federal district court, and then actually get the people to the hearing while the hearing is taking place. And in our instance, there's the question of whether you have to have a separately admitted attorney in the district where the arbitration happens to be sitting in order to pursue the enforcement of the summons. So the title of this was The Horrors Associated with Bringing Non-Party Witnesses and Their Associated Documentary Evidence into a arbitral proceeding under the Federal Arbitration Act. And now you can see why there are horrors associated with that. I'll mention one other little filigree while I've got it. In the 4th district, which is one of the districts that says there is no pre-trial discovery, pre-hearing discovery before witnesses, before an arbitrational hearing is actually established. There is the COMSAT, C-O-M-S-A-T Corp versus NSF case, which is 190 Fed 3rd 269. It's a 1999 case, which was before the broadening of the Federal Rule 45. But it holds that there is no pre-hearing discovery from non-party witnesses. And then it says that the complainant argues quite persuasively that in a complex case, such as this one, the much lauded efficiency of arbitration will be degraded if the parties are unable to review and digest relevant evidence prior to the arbitration hearing. For this reason, in Burton, we contemplated that a party might, under unusual circumstances, petition the district court to compel pre-arbitration discovery upon a showing of special need or hardship. That's 614 Fed 2nd 391 they're citing. And then it goes on to say, we do not attempt to define special need except to observe that at a minimum, the party must demonstrate that the information it seeks is otherwise unavailable. So there is a potential for an exception to the exclusion of pre-hearing discovery in the 4th Circuit if you can establish special need, which would include that the information is not available in any other way. But does that mean that you have to get an advance ruling from the arbitrators that they're going to exclude, for instance, hearsay or unauthenticated documents from a third party that otherwise are reliable, that might otherwise establish the same facts? I don't know the answer to that, but it just is one more horror associated with obtaining non-party testimony from in a Federal Arbitration Act proceeding. So with that, I've said a whole lot. Would y'all like to open up the mics and discuss this or any personal experiences that you've had? Dan, I see it looks like you might either be on a separate line or not, but did you have anything to add to this since you've looked so heavily into it? Anybody else have some items that y'all want to throw out as being unanswerable questions? Okay, well, read the cases that I sent to you, and you can tell that they raise as many questions as they answer. But contemplate taking, well, first of all, when you're drafting your arbitration agreements or any agreement that has an arbitration clause in it, think heavily whether you specially set our Federal Arbitration Act instead of a State Arbitration Act. You might look into which circuit you want to place your hearing in so that you can have a more favorable circuit like the 8th Circuit instead of a less favorable circuit like the 11th Circuit. In order to get non-party discovery, if you're the party that's not likely to have the fundamental information you need, or if you know, for instance, that the people that are involved are all independent consultants or whatever, and they're going to scatter to the wind, they'll all be non-parties that you need to get evidence from. And also, when you're choosing your arbitrators, think about where they sit and whether that affects your discovery rights and your ability to bring in the testimony and documented evidence that you need. So thank you for your attention. Y'all have a great afternoon.